you guys. How is everybody? I know it's so late. Thanks for being here with me. I really wanted to do this. I wanted to catch us up on Lori. Jury selection begins Monday. Monday, you guys. We're that close. And now she's now she's pulling out all the stops, being extra in the absolute worst way, a way that literally nobody is enjoying. Seriously. I mean, I like you know, somebody who's a little eccentric and not afraid to let their crazy slip out every so often. Okay. But this is not that. This is just being an asshole to be an asshole. It's too much. So, and the things that she has accused the prosecuting attorney of are ridiculous. And I want to say a special shout out, which like Nate Eaton doesn't need this from me. Like he's got a big, huge channel and he's doing his news and all of that stuff. But um, I wasn't always a curator. I started out as a subscriber, and Nate has been on this case from the very, very beginning, and he's never stopped. He's never stopped caring about what happened to Charles Vallow, what happened to Tammy Daybell, what happened to JJ and Tylee. He's never stopped caring about them and advocating and pushing for there to be justice. And so he has the documents, and I'm not going to play like his actual stream because you guys should hear what he has to say for yourself, and I'll drop the link. But I'm gonna, he has the all the the documents themselves, and I can read, so I'll read them to you guys and we'll talk about it, and then I'll let you guys go because I know it's late. I mean, it's almost 10 o'clock here for me. That's Central Standard. I know it's almost 11 in Eastern. So, I just, I'm over Lori Vallow. I can already tell that the minute that trial starts, I'm just going to start out on a level 7 spicy. There's just no way around it. She just grates my nerves. She has the most audacity. I can't, every time I think there's no way she could even show up with more audacity. Every single time, here she comes with all the audacity. It's ridiculous. Let me say hi to you guys and then we'll get into it. Hey, boss lady. Well, all right, babe. I will, when you hear this on the replay, thank you for stopping by. I appreciate it. I hope you enjoy the replay. Hey, Jenny, good to see you. Hey, nope, not today. Hey, preschool granny. Good to see you guys. Hey, call me Sadie Jennifer. Let's see. I think I said, yeah. Okay. All right. So, also, I was in a bit of, just chit chat a little bit real quick before we get really started. There's a trial that's starting tomorrow, and I was in a bit of a conundrum because normally, tomorrow our schedule would be to go over Anissa Weier's sentencing hearing, but there's a trial that starts tomorrow that is a trial from back in, oh my gosh, you guys, like 2007 or 2008, where a woman is accused of murdering her husband. She was having an affair and he caught her and was going to divorce her. And she was like, no, I think murder's better. And so she slipped him some medication and set fire to the house with him inside of it. And she was tried and then she was convicted, but her conviction was overturned and she was granted a new trial in 2018. Now, let me just say this. That is super rare. It is really, really hard to get a new trial, especially because the burden shifts. It then becomes solely on the defense. It's and to get a new trial is very, very rare. So I was really, really interested in this trial, and I don't know what to do because there's no way to really recap a trial like this at night. And I just don't know what to do. So I want to ask you guys, what do you think? Hey, Neat Noodle, good to see you. Hey, Violet, good to see you, babe. Hey, Low Red, good to see you. I don't know what to do. So you guys think about it. Let me know in the chat. Whatever you guys decide, we'll do. Because I don't really want to stop abruptly. with the Slender Man. But what I was thinking as a compromise is I can, since the sentencing hearing is only like an hour and a half, I could do that tomorrow night, but much earlier than this. I'm not doing 10 o'clock at night anymore. But then do that trial during the day. I don't know. You guys let me know. I'll do whichever one you guys decide you want. All right, so let's get on over. Let me share this with you guys. This is, let me give you the link. All right. Let me put this in the chat really quickly so it's also Nate has a new fancy studio with all the things. It's really cool. I'm so pleased to see and happy for him that he's, doing so well. But this is where the video comes from. And so please go back and watch it. It's a really good video. It's really informative. And yeah, go give Nate a watch. All right, here we go. So this is one of the motions that she has filed. And it's, the defendant, Lori Daybell, hereby requests both case numbers listed above be dismissed for prosecutorial misconduct. All right, let me turn the volume down. What the heck? Why did this do this? There's Nate. Hey, Nate, what up? Ugh, hold on a minute. This is the wrong. I don't know what this did. So annoying. All right. Here we go. Give me just a sec. All right. Everything on my desk is disorganized and I can't get to stuff. So there we go. All right. You guys ready? Let me share the screen and then we'll fix it. Sorry about that. I pushed the wrong button. It's late. This is why I can't be this late. This is why I cannot go this late, because I am just like done. That's true. That's a good point. I love Nate. I really do. Well, we'll figure it out. Okay, so here it is. On or about September 6th, 2024, Treena Kay directed the Chandler Police Department and the Gilbert Police Department to refuse to provide public documents to the defense, interfering with the defense right to conduct an investigation. 2. On or about January 30th, 2025, Treena Kay obtained and distributed attorney-client privileged communications between the defendant and her appellate attorney in Idaho. Number 3. On or about March 11th, 2025, Treena Kay gave legal advice to defense witness Nate Eaton in an, quote, off-the-record conversation regarding how to avoid being served with a subpoena from the defense. Ms. Kay has personally thrown her ethics and duties out the window in order to win this, quote, high-profile case in front of a worldwide audience. Yes, Lori, that's the problem. I'm apparently a faster reader than Nate. Oh, wait, hold on. All right, here we go. Because this court has ignored the state's conduct, Treena Kay become more blatant in her disregard for her ethical obligation. This is sadly similar to her longtime boyfriend Juan Martinez's behavior in a, quote, high-profile case years ago here in Maricopa County. It seems her behavior is not original. This court is obligated to discipline officers of the court. How the heck did that happen? Oh, it's playing. Hold on. What is wrong with me today? All right. Because this court, blah, 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 it seems her behavior, the court is obligated to discipline officers of the court for misconduct. This misconduct is egregious and needs to be addressed by the court. The actions that the defendant is seeking this court take as a result of Ms. Treena Kay's misconduct are as follows. She wants, hold on. Sanctions by the court, disbarment, and she wants her dismissed from this case, from both of these cases, both of her criminal cases. Why is this not even on stream? Did I just read that whole thing to you guys? Oh my gosh. Well, you don't need to see it because I read it. Okay, there it is. Now, it's this part that is the low blow and absolutely ridiculous. So this is sadly similar to her longtime boyfriend, Juan Martinez's behavior in a high-profile case years ago here in Maricopa County. Okay. Lori, cut the crap, all right? She's talking about Jodi Arias, of course. I don't know what Lori is talking about. I enjoyed the trial. I thought Juan Martinez did a great job, particularly getting her caught up on cross. That's what he does. It's a low blow. It's unnecessary. And she got personal, like you're supposed to keep it to your case. It has not, her being Juan Martinez's boyfriend has nothing to do with anything. You're ridiculous. No, I'm on Streamlabs. No, I'm okay. Lil Red, it's me. I can't blame no technical issues, nothing. It's just me. It's me. I'm the problem. Like, Lori, we need a palate cleanser already.
What you just said is one of the most insanely idiotic things I have ever heard. At no point in your rambling, incoherent response were you even close to anything that could be considered a rational thought. Everyone in this room is now dumber for having listened to it.
That's how she makes me feel. It's so preposterous. It's absolutely ridiculous. I mean, whatever, Lori, you're ridiculous. All right, so let's keep going. Here's where he wants it. All right. So the state answered this. Hold on. Now, the other issue is this Gilbert Chandler Police Department situation. Lori, I have broke this down for you 17 different ways from Sunday. What you're requesting does not exist. Just because there was a camera in the interrogation room, which you were sitting in, does not necessarily mean that the camera was turned on. And she specifically mentioned the internet. It's online for everybody. Okay. Yeah. It's the body cam. It's your interview, what you said, what you and Melanie Bangs Gibbs said in that interview. Okay. It's their body cam footage. That's what's on the internet. Lord. All right, here we go. So now the state has answered. The state of Arizona, through undersigned counsel, requests this court deny defendant's motion as there has been no prosecutorial misconduct. The state responds to each of the three allegations by noting that the, quote, facts as alleged by the defendant as to each issue are simply untrue. On September 6, 2024, the state became aware that the defense had made a public records request to the Gilbert Police Department. The state emailed defense counsel and asked them to request these items from the state. The state also requested the documents listed in the defendant's public records request from Gilbert Police Department. When the state obtained the documents that the defense had requested from the Gilbert Police Department, the state disclosed them on October 1st, 2024 as bait stamped pages, blah, blah, blah. On September 18th, 2024, the state became aware that the defense had made a request to the crime analyst section of the Chandler Police Department. The state was advised that the defense request was improper because it was made to the crime analysis section rather than going through the public records request process. The state was advised that the Chandler Police Records Specialist section spoke with Lori Mose, who sent a request for the, quote, log records for all digital devices downloaded. The state was also advised that the Chandler Police Department did not know what was being requested as, quote, log records. Chandler Police Records Specialist section advised Laura that when computer crimes detectives are involved in a case, their supplemental reports contain download information on all devices that the Chandler Police Department extracts data from. All reports relating to the download of Charles Vallow's device had previously been disclosed to defense. Additionally, all extractions relating to the download of Charles Vallow's devices have previously been disclosed. Oh, this sounds like Letitia, wherein the request is, wrong. It's sent to the wrong place. It's the wrong item that you're requesting, or you're not specific, or they don't know what you're talking about. And somehow it's Chandler Police Department and the state's fault that this has happened. You don't know how to, I mean, Lori, you're representing yourself, for the love of Pete, right? Getting a FOIA request should be the easiest thing that you do, right? I mean, you're going to represent yourself. You've only ever represented yourself before in a civil proceeding, which was a divorce. Okay. Very different than a criminal trial. All right. But I would think in that, giant gourd of yours that you're so smart, you're smarter than everybody all the time. Right. Everybody else is just so beneath you that a simple FOIA request you would know how would be within your scope of capabilities. I have a good enough diploma, and even I know how to make a FOIA request, Lori. Just saying. All right, here we go. On September 19th, 2024, the state filed state's motion for defense to comply with Rule 15.4E. On October 15th, 2024, the court issued a minute entry denying state's request. Oh, hold on. On September, I already got that part. Why does this? Yeah, I need to keep going. Hold on. The state is unaware of any other public records requests at either to Chandler Police Department or Gilbert Police Department by the defendant or her defense team. On February 6, 2025, the state disclosed MCSO jail calls made by defendant Lori Vallow between 10/24/24 to 1/24/25, as well as jail messages and photos from defendant Lori Vallow's tablet for the time period of 10/24/24 to 1/24/25. On March 18th, 2025, the defendant filed a motion to dismiss for violation of, hold on, let me see if he scrolls up a little bit more. On March 18, 2025, the defendant filed a motion to dismiss for violation of attorney-client privilege communications. The state is currently working on a response to this motion. The state hereby incorporates its response to defendant's motion to dismiss for violation of attorney-client privilege communications as part of this response. On March 6, 2025, defendant filed a supplemental 15.2 notice as to both these of her criminal cases. The state requested that separate notices be filed for each cause number so the state would know which defenses and witnesses applied to each case. Seems reasonable. On March 7th, the state learned that the defense noticed witness Nate Eaton is a reporter from Idaho. On March 12th, 2025, defendant filed a supplemental 15.2 notice. For one of her criminal cases and a separate 15.2 notice for her second criminal case. On March 16th, 2025, the state filed a motion to preclude all witnesses noticed on defendant's supplemental 15.2 for this cause number. At the final trial management conference on May 18th, 2025, the court heard from the parties on this motion. The state advised that it did not have contact information for most of the witnesses. The state also advised that one of the defense witnesses, Nate Eaton, was a reporter, which he is. That's all true. Nate Eaton contacted this prosecutor after court on March 18, 2025, and this prosecutor called Mr. Eaton back. Mr. Eaton advised this prosecutor that his knowledge about this case comes from his interviews and investigation as a reporter. Mr. Eaton also advised that he had not been served with a subpoena by the defendant, and he hoped to be in court for this trial. The prosecutor advised Mr. Eaton that even if he was not served, he could still not be in the courtroom if he was a noticed witness, and the rule of exclusion was in place. This prosecutor advised Mr. Eaton that this prosecutor would try to interview the witnesses and file a motion to preclude those that should be precluded at the end of next week. The prosecutor did not advise Mr. Eaton how to avoid service of a defendant's subpoena. So, like we talked about before, this is Lori's petty way of keeping Nate out of the courtroom. That's all that it is, because there is an exclusion. You cannot sit in the, you cannot hear the trial until you've testified and been released from your subpoena. So this is just more baloney from Lori. Okay, so Jenny, thank you for gifting a membership. I appreciate that. Thank you so much. I appreciate that so much. And nope, not today. Got it. So thank Jenny for that. Thank you for supporting me in the channel. I don't understand. I mean, I'm never going to understand what goes on in Lori's brain for real. Like, I feel like if I start understanding what she's talking about, we're all going to be in big trouble. All right. So there's that. That's the one. All right. Okay. The state, through undersigned counsel, hereby submits the state's final trial management conference statement for the above entitled action. 1. The charges and sentencing range, including any sentence enhancements alleged. Count 1, conspiracy to commit first-degree murder, C1F, dangerous. Life without the possibility of release on any basis until the service of 25 years. Okay, so that's our most. All right. Now, let's see. No, there was no plea offered. This is what they'd like to have jurors. They'd like to have 12 plus 4 alternates. This is the state's witnesses. That's from the police department. Let's see. Civilians. Ooh. I do not see Melanie Gibb. Interesting. Huh. Interesting. Brief statement of case to be read to jury. The state alleges that on July 11th, 2019, at approximately 7:37 a.m., Charles Vallow arrived at her address to pick up his son from the residence where his wife, Lori Vallow, in parentheses, Lori Daybell, was living. The state further alleges that Lori Vallow Daybell conspired with her brother, Alex Cox, to kill her husband, Charles Vallow, so she could marry Chad Daybell and obtain money from Charles Vallow's life insurance policy and from Social Security. Special jury voir dire questions to be filed separately. List of standard jury instructions plus original and one copy of any special jury instructions to be filed separately. So there is that. That's what they are intending. Okay. The defendant. This is Lori now. Okay. Sorry, you guys, it's hard for me to read the chat and be on this other page. So good night to anybody. Let's see. Good night, Brandy. Thank you for being here. I appreciate it. All right. So here's the witnesses that Lori doesn't want. The defendant, Lori Daybell, requests that the state be ordered to exclude the following witnesses: Nancy Jo Hancock, Christina Atwood, Kay Woodcock. The state's witness listed above, hold on a second, are not for factual testimony. They only have to offer speculation and hearsay. Federal rule of evidence, need for personal knowledge. A witness may testify to a matter only if evidence is introduced sufficient to support a finding that, she's underlined this, so let me get my good, I'm very serious voice on, that the witness has personal knowledge of the matter. This rule would prevent testimony to the subject of hearsay because there was no personal knowledge. The alleged witnesses were not in communication and had no knowledge prior to the alleged crime. Their presence was not in location or proximity of victims or the defendant. 2, if a witness alleged interpretation, contribution in name of another is prohibited. No person shall make a contribution in the other person or knowingly permit name to be used to effect such a contribution. Hold on a second. Okay, let's see. Excludable above as legal conclusion. Testimony is unlikely to assist because, among other things, it has nothing to do with defendant's actual case. Okay, let me just stop you right there. Lori, you thought that you were the beneficiary of Charles Vallow's life insurance. And the life insurance was transferred to Kay Woodcock as the beneficiary, which made you mad. So she does have knowledge. She does have knowledge about what was going on during the interim, which is why Charles Vallow named her the beneficiary and not you. So stop playing. Lord. Okay, then she cited another case law. Impeachment testimony demonstrates untruths in statements, especially used in prior trial, thus proves guilt by implication, and therefore such statements and are incriminating in any meaningful sense of the word. Basically, she is saying they testified in previous trials And so it's just basically they're saying if I'll tell you, the state's witnesses above are meant to deprive the defendant to right to due process and right to a fair trial. These witnesses will not be testifying to facts, but opinion, speculation, and hearsay, creating prejudice and bias for the defendant in front of the jury. In conclusion, the defendant requests the above listed witnesses are excluded from testifying at trial since it was discovered in their pretrial interviews that these witnesses have been communicating with each other regarding the defendant. I mean, Lori, were they not allowed to speak to each other? I mean, pre-trial. Do you know how, I mean, you were arrested and charged back in 2020. Your trial wasn't until 2023. I mean, were they not supposed to ever talk? Stop it. You're being ridiculous. I mean, it's a nice try, though. I see where you're going with this, but I don't think you'll be successful. Oh, wait, hold on. And let's see, with each other regarding the defendant and these cases. None of these communications between these witnesses have been turned over to the defense from the state. It was discovered by the defense in these pretrial interviews that that much of the information that these witnesses gave in their police interviews was gained from speaking to Kay Woodcock long before they were interviewed by police. All three of the above mentioned state witness should be excluded from why don't you write that they should be excluded from testifying at the trial 3 more times, Lori? Come on. This is ridiculous. I don't think she's going to be successful. All right. Oh, went too far. The state of Arizona, through undersigned counsel, blah, 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 blah. Defendant argues in her motion that the witnesses are not for factual testimony. They only have to offer, this is the state's response, speculation and hearsay. The defendant writes, among other things, that these 3 witnesses lack personal knowledge. Defendant seems to argue that therefore the witnesses are not relevant and should be excluded. State presumes defendant meant precluded. State disputes these allegations and provides that these objections are more properly raised at trial, not by a pretrial motion. Amen. Okay. Let me just say this. This goes to the weight of the evidence, which, Lori, is the jury's job. I'm bummed, though, that there's not going to be a Melanie Gibb. The defendant is charged with conspiracy to commit first-degree premeditated murder. The state can use both direct and circumstantial evidence to establish that the murder was premeditated. The courts have long held that although motive is not an element of homicide, it is relevant. The fact that the defendant has some motive, good or bad, for committing the crime is one of the circumstances which, together with other circumstances, may lead the fact finder, in this case the jury, to conclude that he did, in fact, commit the crime, whereas lack of any discernible motive is circumstance pointing in the direction of his innocence. The state submits that the motive for this murder is that Mrs. Vallow, now Daybell, wanted to kill her husband so she would obtain the proceeds from his life insurance policy, Social Security benefits, and be free to marry her current husband, Chad Daybell. Each of these witnesses is relevant to establish premeditation and motive. I agree. Submitted March 23rd, 2025. All right. All right. The state of Arizona, through the undersigned counsel, responds to defendant's request to disclose 404B evidence. The state advised that it intends to admit evidence that the murder was committed for financial gain and allow the defendant to marry another person. The state will admit this evidence to prove murder was premeditated. So Lori made a motion to disclose all 404B evidence, okay? The state will admit this evidence to prove the murder was premeditated and show the motive for the murder was to obtain the proceeds from a life insurance policy for Charles Vallow's Social Security payments for her surviving child and herself as a mother, and allow her to marry the person with whom she was having an affair. Evidence of the premeditation and motive will be shown through witnesses and iCloud documents. The state will call a witness from Banner Life Insurance Company to show that the defendant contacted the victim's insurance company within 4 days of the murder of her husband to collect the proceeds because she believed she was the sole beneficiary. During this recorded call by the defendant, she provided a different story about how her husband died by telling the life insurance representative that her husband's death was an accident. Jeez, Lori, so now you're just out here lying to people. Hang on just a second. I want to I see it on thank you, LGS or LGZ. I appreciate that, babe. I really do. Oh, here it is. Thank you very much. That was really generous. Thank you for the super sticker. I appreciate that. Thank you. Thank you, LGZ. I can't even talk today. I don't even know why I thought this was a good idea to get up here and read like this for all this time whenever clearly words are hard for me. All right, here we go. When Lori, I don't think Jesus is a fan of lying. Just saying. When the defendant learned she was not the beneficiary, she advised the person she was having an affair with, quote, "So I talked to the insurance company. He changed it in March, so it was probably Ned before we got rid of him. They can't tell me to who, of course, but it's done. I'll still get the $4,000 a month from Social Security." Statement by the party opponent about the life insurance proceeds is evidence of the premeditation. The defendant later contacted the sister of Charles Vallow to confront her about the fact that Charles Vallow changed his life insurance beneficiary. The state will present testimony from an investigator with the Social Security Administration and iCloud documents to show that the defendant was aware of how much money from Social Security she received for her son JJ and herself as a result of the death of Charles Vallow. Hold on. Before she went to speak with anyone at Social Security. This testimony and evidence further support that the defendant premeditated the murder of her husband. Yes, she did. The state will present testimony from witnesses who were friends with the defendant and iCloud documents to show that the defendant used her religious belief system as a way to justify the premeditated murder of her husband, Charles Vallow. These witnesses and documents were disclosed to the defendant on December 12, 2023, January 9th, 2024, and February 26th, 2024. Some of this was 2 years ago and at least 1 year ago, Lori. So, okay, now we were wondering about this. So the defendant, Lori Daybell, requests that this court, the state, and MCSO allow the defendant to wear civilian clothing during all court proceedings, jury selections, and all trial proceedings. This request is made pursuant to the 5th, 6th, 8th, and 14th Amendment of the United States, blah, blah, blah. We all know this. The public and prospective jurors are viewing the defendant's proceedings and on worldwide media. The defendant's appearance in jail uniform will constitute a violation of the defendant's due process rights. Deprivation of the defendant's right of wearing civilian clothing to all court proceedings, pretrial, and trial. The 6th Amendment of the United States Constitution and Article 2, Section 24 of the Arizona Constitution guarantee a criminal defendant has protection against improper intrusions by the prosecutor or other government. This is so ridiculous. Or other government agents. Lori, all you have to do is argue that it's prejudicial. There is case law about this. You didn't even have to cite the Constitution. There's case law about this. You don't have to be so aggressive. This is ridiculous. Lord. State or MCSO's failure to adhere willfully or inadvertently would deny and violate the defendant's due process rights. Therefore, the defendant requests that the court order to allow the defendant the fundamental right to wear civilian clothing in all court proceedings, jury selection, and trial. In parentheses, both trial. Well, listen here, Lori. This is like a non-issue. I don't even know what you're doing, but let me just say this. If you come, let me tell you what's going to be prejudicial to the jury. I don't give a rat's fat kneecap whether you wear the Motel 6 line of trial attire for defendants or you wear the Hilton line. Either way, if you show up with that bootleg Charo Lhasa Apso Shizu hairstyle that you've been wearing to the court proceedings, and you continue to use the hot Cheeto dust for your lipstick and your rouge, they're going to be judging you anyway. That is a terrible look. It's too harsh, and it ages you incredibly. In fact, let me just say this. Go ahead and wear that. Looking like the cowardly lion out here. It's absolutely ridiculous. That's what you need to be worrying about, what you're going to do with that hair. The defendant, Lori Daybell, requests this court, the state, and MCSO to allow the defendant to have no restraints, handcuffs, or shackles while in the courtroom during all court proceedings, jury selection, and all trial proceedings. The request is made pursuant to the 5th, 6th, 8th, and 14th Amendments of the United States Constitution, Brady versus Brady versus Maryland, all of these things. The article on December 6, 2024, the defendant was granted self-representation as pro se status or pro per status. It has been extremely difficult for the defendant to manage files, take copious notes in all pretrial hearings with handcuffs. It would be impossible to represent oneself at a trial under these conditions. Also, the defendant's appearance in restraints, handcuffs, or shackles violates her due process rights and impairs her ability to perform writing tasks in her defense. If the defendant is going to properly be allowed to defend herself, she must not appear separate or different from the state representative. To be able to stand, walk, move about the courtroom as the other attorneys is imperative in a fair trial. If any imposed MCSO restraints cause this defendant to appear to the jury different from the state's representative, it would violate the defendant's due process right and the right to a fair trial. The defendant's documented behavior. The defendant's documented behavior for the last 5 years while in custody warrants no restraints necessary during trial at all. This defendant has been through a long trial without any misbehavior at all. This defendant has only displayed stellar behavior all of the time that she has been in the custody and incarcerated over the last 5 years. Therefore, the defendant requests that all security restraints be waived for this particular defendant. The defendant also requests the use of a pen at her trial table to take notes. At the minimum, the defendant requests this court to order the state and MCSO remove restraints, handcuffs, and shackles for all trial proceedings, both trials. Okay, the judge already told you about this, Lori. This is ridiculous. Lori, you're going to be on like a tether, okay? The jury will not see it. You will be able to move from your table to the podium to be able to directly or cross-examine witnesses. Should you need to pass a witness a piece of evidence, there will be somebody from your table who will do that for you. Likewise, at the states, whoever is conducting the cross-examination or the direct will stand at that podium, and someone else at the state's table will, if a witness needs a document or something to look at and they need it to be handed to them, somebody else from the state's table will pass that to them. Like, were you not? I mean, I was there in court and I'm not the one on trial, and even I know this. lady. Like, what's wrong with you? I mean, don't answer that. It's rhetorical. I know what's wrong with you. You're just a terrible person. All right, hold on. All right. Maricopa County Sheriff Jay Sheridan respectfully responds in opposition to defendant's motion for defendant to have removed restraints in trial. The following memorandum of points and authorities supports the Sheriff Skinner's response. In defendant's case, MCSO has reviewed defendant's request and recognizes that defendant may need to move about in the courtroom as she is appearing pro se. However, pursuant to MCSO's policies and procedures and their duty to maintain control and custody of inmates and ensure the safety and security of the courtroom, defendant cannot go unrestrained. As such, MCSO recommends, to ensure the safety and security of the courtroom, the use of a RACC vest and, in addition to detention officers in the courtroom during the defendant's trial. The RACC belt is designed to temporarily stun an attacking detainee, thus buying time for courtroom security to react. The belt sits comfortably on the defendant with straps adjustable to a particular defendant's body type. The belt is not visible to the jury. Further, the belt works on a one remote, one sensor system, ensuring that activation of other remotes will not trigger the vest accidentally. Oh, let me hold that clicker. Without any restraints in the courtroom, MCSO would have to recommend unarmed detention officers and an armed sheriff's deputy in the courtroom. All right, let's see. Yeah, this is just, hold on, let me see. Oh my God. Lori. Now she's objecting to the jury questionnaire. More specifically, the defendant objects to question number 12 of the jury questionnaire and suggests the current language would be replaced by the following. The state alleges on July 11, 2019 at approximately, Lori Daybell denies this allegation, that she wants this added. Oh my God. Shut up, Lori. The defendant would also like to bring to the court's attention that the state's been entirely too patient. Hold on. That the state's final trial management conference pretrial statement that was filed March 13, 2025 was not a joint statement, and the state did not confer with Mrs. Daybell or any members of her defense team prior to filing this statement. The defendant requests that this court also require the state to amend the language in the final trial management conference pretrial statement that was filed on March 13th, where it states 6. Brief statement of case to be read to jury to reflect the defendant's objection and suggested language. Oh my God, Lori, shut up. Lori, let me just clue you in on something here. The fact that they're filling out a freaking jury questionnaire implies that you deny the allegation. You've pled not guilty, which is why we're having a jury trial in the first damn place. If you pled guilty, what would we be having a jury trial for? Ma'am? Dumber than a box of hair. All right, here we go. See, this is why I say all the time, the most dangerous people are people who are stupid but don't know that they're stupid. Let's see. The state of Arizona, through undersigned counsel, requests this court preclude defense expert Lonnie Dworkin as a defendant has not complied with rules. On March 6, 2025, defendant filed a supplemental rule notice listing defense's witnesses for both cases. In the defendant's supplemental notice, she lists 11 potential witnesses, but does not include any addresses or contact information for any of the witnesses. Defendant supplemental 15.2 also does not provide any written or recorded statements of the witnesses. Many of the named individuals were not contacted by the police, and therefore the state cannot readily obtain that information. On March 7th, 2025, the state reached out to defendant's paralegal and asked if the defendant could identify which witnesses and defenses were relevant to the case, to one case versus the other case. On March 11th, 2025, the state emailed defendant's paralegal, Ana Elena Ramirez, and asked if the defendant would set up interviews with the 11 witnesses, or if they would prefer to set them up, then the state would need phone numbers for the witnesses. In a later email, March 11th, 2025, the state asked if it would be better for the state to reach out to witnesses, or if the state should go through the defense investigator, Jeff White. On March 12th, 2025, Ana Elena Ramirez responded and advised that the state should go through investigator Jeff White, but CC Mrs. Ramirez in case he needed assistance with scheduling. On March 12th, 2025, the state emailed defense investigator Jeff White and asked if he was able to set up an interview with whichever witnesses Mrs. Daybell intended to call for the 2021 case. The state provided availability to conduct these interviews on Friday, March 21st, 2025. The state did not receive a response to this email. On March 12th, 2025, the defendant filed another supplemental 15.2 notice of defenses and witnesses. In this supplemental notice, the defendant notices the same previous 11 witnesses without any addresses or contact information, plus she included 2 more names. That sounds about right. To her potential list of witnesses. One of the witnesses, Lonnie Dworkin, was mentioned by the defendant at the status conference on March 11, 2025, as a defense expert. On March 12, 2025, the defendant provided the state with Mr. Dworkin's CV, which indicates he is a, quote, certified computer forensic examiner. The defendant did not provide a report by Mr. Dworkin or a summary of his opinion. Upon receiving the supplemental 15 notice with the defense expert Lonnie Dworkin, the state emailed both paralegal Ana Elena Ramirez and advisory counsel Pamela Hicks and Robert Abernathy. The state again requested and contacted information for the witnesses, as well as if the expert Lonnie Dworkin had authored a report. The state requested the defense comply with Rule 15.2 and either provide a report or a summary of the subject matter and Mr. Dworkin's opinion. Advisory counsel forwarded this request to defense investigator Jeff White. Mr. White did not respond to this email request. Oh no, they're on the ignore? What? On March 13th, 2025, the state emailed defense investigator Jeff White and defense paralegal Ana Elena Ramirez and asked what specifically Mr. Lonnie Dworkin was being hired to do and the estimated date of completion. The state also requested the addresses and contact information for all noticed defense witnesses. Neither Ana Elena Ramirez nor Jeff White responded to this email request. Wow. On March 14th, the state again emailed defense investigator Jeff White. Jeff, what are you doing? And Ana Elena Ramirez, what are you doing? Requesting contact information for all witnesses listed on the supplemental 15.2, as well as to provide an update on what Lonnie Dworkin was hired to do and the estimated date of completion. The state also requested the addresses and contact information for all noticed defense witnesses. Neither Ana Elena Ramirez nor Jeff White responded to this email request. The rudes. Whew. On March 14th, 2025, the state again emailed defense investigator Jeff White and paralegal Ana Elena Ramirez requesting contact information for all the witnesses listed on the supplemental 15.2, as well as to provide an update on what Lonnie Dworkin was hired to review and when that review would be completed. The state has not received any responses from the defense investigator Jeff White or paralegal Ana Ramirez as to any of the state's requests. Defendant is in violation of Rule 15.2C, which states, at the same time the defendant files a notice of defenses under B, the defendant must provide the following information: name, addresses of each person other than a defendant the defendant intends to call as a witness at the trial, and any recorded statements of the witnesses. The state has requested on 4 separate occasions for the defendant to provide the addresses and or contact information for the witnesses noticed in her supplemental 15.2. To date, the state has not received a response. The defendant is in violation of Rule 15.6b, which provides any party who anticipates a need to provide additional disclosure no later than 30 days before trial must immediately notify both the court and all other parties of the circumstances and when the party will make the additional disclosure. Sorry for my creaky chair. I need some WD-40. Defendant has indicated that they requested funding for Mr. Dworkin around January 5th, 2025, but just received approval for funding March 10th, 2025. Defendant's oral notice of computer expert 19 days before trial does not comply with Rule 15.6. Furthermore, defendant does not comply with Rule 15.2C2B, which requires the defendant to provide any report by the expert and the results of completed physical examination, scientific examination, or comparison conducted by the expert, assuming Mr. Dworkin has not completed a report. The defendant still has not complied with the rule. Let's see. At this time, it's unclear whether Mr. Dworkin has started whatever analysis, review, examination he plans to do and or when this work will be completed. On March 12, 2025, the state emailed the defendant's paralegal, Ana Elena Ramirez, about Lonnie Dworkin. The state was provided with the fact that OPDS just approved funding for Mr. Dworkin March 10th, 2025. On March 13th, advised the state that it was her understanding that Mr. Dworkin had not done any work yet on the case, or if he has, it's been minimal in the last couple of days. Mrs. Ramirez CC'd defense investigator Jeff White and advised that Mr. White was the person who was in contact with Mr. Dworkin. Mr. White did not respond to this email. To date, the state has received no response to the request regarding the subject matter of Mr. Lonnie Dworkin, nor has the state been advised of when Mr. Dworkin's work will be completed. On March 11th, 2025, the defendant advised the court that she was ready to start trial on March 31st, 2025. Defendant has repeatedly asserted, and she has, her speedy trial rights. Rule 15.7a requires any party moving for sanctions for disclosure violations must include a separate statement that the moving party has personally consulted with opposing counsel and has made good faith efforts to resolve the matter. The state has filed a separate statement in support of the Rule 15.7 request for sanctions pursuant to Rule, hold on, stated, let's see, the defendant has represented herself since December 6, 2024, when the defendant hey, stop. Alice, stop that. Crap, I can't see this last part. Shoot. Hold on, let me play it. Let's see if it'll be a little better. When the defendant asked to represent herself, she advised that she had been studying the criminal case of procedure for Idaho and Arizona for the last 5 years and was very prepared for trial. During the colloquy to ensure the defendant was prepared to represent herself, the defendant was required to sign a waiver form and was advised by the judge that she would be held to the same standard as an attorney regarding knowledge of courtroom procedure. Rules of evidence and rules of procedure. The defendant agreed to this. Per defendant's paralegal, defendant requested funding for the expert on January 15th, 2025, received. Defendant could have requested a continuance on March 11th, 2025 to allow time for her expert to complete whatever testing review. Instead of complying with the rules, the defendant filed another supplemental on March 12th, 2025, and noticed expert Lonnie Dworkin without including any of the requirements. The state has repeatedly requested the defense either set up interviews with their listed witnesses or provide contact information so the state can interview the witnesses. The state has also repeatedly requested information regarding the subject matter of expert Lonnie Dworkin and any information as to when he'll be done. Okay, the state's made good faith efforts. So basically, trial in this matter is set to begin in 15 days. The state will not have time to interview the 11 defense witnesses and file any appropriate motions in limine, nor will the state have time to interview defense expert and determine if the state needs an expert to rebut whatever Mr. Dworkin will opine. For these reasons, the state requests the court preclude all 12 witnesses. Wow. Which, I mean, she's not wrong. I mean, hold on just a second. This is a stupid move, Lori, by the way. If you're trying to get them caught up in some sort of situation like you lucked into in the trial in Idaho, where the judge had no choice but to remove the death penalty and from the list or from the possible penalties because they were late in getting you discovery or your attorney's discovery, and that was the penalty, is that the death penalty would be removed. That was their, they got in trouble, and that was the consequence. He punished the state by removing the death penalty. If you're looking for some crazy ass loophole that's gonna get you somewhere in this case, you're barking up the entirely wrong tree. Like, you're not even in the right area. You're not in the right forest. You're not near the right tree. No, none of this is going to work because all of this is on you at this point. You decided you wanted to be the attorney. You knew you were going to be held to the same standard as an attorney. And it is your issue and your fault and your problem that you don't have. You have to turn that over. You're over here searching high and low for a video that you swear exists, that we all know doesn't exist. You've got all the time in the world to be, claiming prosecutorial misconduct, and you can't even get your poop in a group so that so that the state can interview your witnesses. And they can understand what it is that your expert witness is going to testify to with respect to the download of, I would assume it's Charles Vallow's phone. I don't know what you're thinking. All right, let's skip forward just a little bit. Let's see. I think that might be all of them, but let me just make sure. Here's the schedule. Thank you for this, Nate. I'm so sorry. Nate, I appreciate this. So here's the deal. This is the schedule. All right. Jury selection, March 31st through April 4th. April 7th, opening statements. April 7th through May 8th is the trial. Proceedings begin at 10:30 a.m. Arizona time, 11:30 a.m. Mountain. Live stream begins 30 minutes later. No court on Fridays. Interesting. Let's see what else. Yeah, that's all we got. That's all the motions that she filed. That's ridiculous. I just, she is adamant that she wants a speedy trial. And the reason that she wanted this is because she is expecting this case to be as intricate and complicated as the case in Idaho. And it's while there is a lot of information, there's a lot of discovery, all of those things, right? It's not as complex as the case in Idaho. It's every bit as important, though. Please don't mistake what I'm saying. It's every bit. What happened to Charles Vallow, Lori absolutely needs to answer for. Period. End of just, that's it. That's all. She needs to answer for it. But there aren't as many moving parts in this one as there were in the case of Idaho. And I think what she was hoping is that she would not waive her right to a speedy trial, that she would have to get these, they have a set amount of time when you don't do that between indictment and the trial to follow, all of the things. And she thought she was going to get, by doing this, she was going to rush them and she was going to somehow benefit from that rush like she did in Idaho. And that's simply not the case. She thought that she would further complicate the situation by mid proceedings, pretrial proceedings, throwing a monkey wrench in all of this and deciding that she wanted to represent herself. So Lil Red says, why do they think this trial will take so long? They think this trial will take so long because, quite frankly, Lori is a pro se defense, and it's going to take her longer to do things than it would an attorney who's passed the bar, a licensed attorney. That's why. And look at the fuss that she's putting up. She wants them to include in this questionnaire at the end that Lori Daybell denies these allegations. Duh and or hello. That's why there is a jury trial, because you pled not guilty. If you'd have pled guilty, we'd be moved on into the sentencing phase at this point. There would be no jury. Duh. Nope, not today, says. I agree with you, Jen. However, the murder cases usually take 2 to 3 weeks. I've seen, there are cases that can take 2 to 3 weeks. There are cases that, Todd Mullis's trial was first degree murder. It was 4 days. 4. But they've allotted extra time in case of Lori. The judge said that at the last hearing. So, yeah. All right, you guys. Well, that's all I have for you guys tonight. As you can see, we're getting right up to it now. I think what I'm going to do tomorrow is in the morning, I think I'm going to finish Anissa because that's only an hour. And then I need to look into read this case, because I do want to watch this case. I do want to cover this case, but I have some reservations about about starting a trial with Lori's trial fast approaching. It's only a week away. Well, a couple of weeks away. I don't know. Let me look into this case and see how long they think that the trial is going to last. And that'll give me a better idea. I'd rather, if nothing else, at least I can finish with Anissa, just for some finality. And then we can take a little pause in Slenderman and move to this next trial. Maybe we can do that. We'll see. I'll let you guys know in the morning. All right. That's all I have for you guys tonight. I appreciate each and every one of you being here. Thank you so much. If you haven't done so, please do me a favor. Give your girl a thumbs up or a thumbs down. There were some technical issues. I don't blame you if you have to deduct points in the talent section. No biggie. I'll get over it. I'll be better next time, I promise. Anyway, thank you all for being here. I appreciate it so much. Until tomorrow, I'll see you guys all tomorrow morning. And have a great rest of your night. Thanks for hanging out so late. Bye.
Cause it's Friday, you ain't got no job, and you ain't got shit to do. Well, fuck you.
No malicious intent or effort was towards it.
No malicious.
Finish her!
Minutes later.
We all do a little match sometimes.